Great. Mike, start us off. Let's get framed. We got a lot to talk about today, don't we?
We do. And thanks everyone so much for coming to this week's Huddle. We are going to deep dive into certain paragraphs of the REPC that may not get the attention they deserve. Um, though, which one are we going to start on, Will? Are we going to start on 10, 11, 12? I mean, where do you want to get going with this?
Yeah. Yeah. Thanks, Mike. And hey, welcome, Nikki. Good to see you and your team. Matter of fact, could you do a quick introduction of who's there with you?
Oh goodness. Okay. Um, Pam Vogel and Catherine Hoover. I'm not sure anybody else is on notice here right now. Just us three.
Okay. Hi,
Just? Is
nice.
that just? Man, it's great to see you, Nikki and ladies.
Yay, we're so excited.
Okay. Well, hey, we'll jump into this. So here was the thinking. Starting with paragraph 12, I think we'll start with 12, Mike. I'm going to try to give you some legal perspective on some cases that we've had related to each one of these sections, and maybe what your takeaway here is that you've got some talking points when you go through the REPC and you're explaining these paragraphs. I've given you some talking points for each one. Okay. I know some of you are driving or don't have your screen, but what we have up on the screen right now is section 12 at the top, and we'll go through each one of these. There's some I want to go a little further, into some cases. Not every one of these I have a case for. Um, but let me before I go into section 12, using the contracts or addendum or clauses as a visual presentation tool will make a profound positive impact in your presentation, because inside of these agreements are the complexities. And when you show complexity, you have a reason for a solution to that complexity. And this is where your value is realized. And I've preached this for years now, so sorry if that sounds like a broken record. But that is the reason why I like you to master all of these sections, because when you do, you'll refer to them in listing presentations and with buyers. So when a buyer asks you a question, instead of just answering it, look for ways to inject the form or the paragraph of the Rep C in this case into the conversation and show them instead of tell them. I know you know the answer, or a lot of you do know the answer. Like if I said something like, does a seller need to warranty a stove or something? You might go, well, no, of course not. We don't warranty appliances. But you might also say, well, that's answered in section 10.2 and 10.3. So in 10.2, we explain that this is an as-is purchase. So what I'm suggesting is, instead of answering it because you know the answer, I'm suggesting that you refer to section 10.2 and explain what that says. When you do that, you start showing the complexity, and now they realize they need you, right? So lower commission objections, more value realized, just more power in your presentation, and you're using the form to do that as your visual, right? So much like a teacher would use a visual aid to teach something, use the forms as your visual aid to march and educate someone through the presentation. So that's our high order bit today: improve presentation by using contract language and the forms. Okay. So in section 12, so section 12 has changes during the transaction. Mike, could you pull that down for a sec? So we don't have the answers staring at us right there. Why in the world would a contract need a section that says changes during the transaction? And what issues might we want to address in our agreement with another, in this case, we have buyer and seller selling real estate. Why we want to talk about changes during the transaction? What are we trying to avoid here?
Miscommunication.
Okay. So an expectation on one side, oh, I thought this was okay. And maybe it's damaging. Maybe what I think is okay is damaging, like a seller changing a lease. Well, they're my friends. I'm going to let them out early. So I just changed the expiration of the lease. So see, that could be harmful. So how would that be harmful to a seller if the owner or a buyer? How is it harmful to a buyer if the owner of the property changed the expiration of the lease? Go ahead, Nikki. I know.
Oh yeah, I'm gonna let someone else. Okay, sir, would you put that in a sentence again?
So buyer enters a contract to
Uh-huh.
the property. It has a lease in place, and the owner of the property cuts his friend a deal and says, "Well, hey, why not instead of having it end at the end of this year, why don't we just go ahead and have it end by the time I'm selling the property? So you know, have it end at the end of March. So we'll let
That's a
you out
problem.
by the end of March. Why would that be damaging to the buyer?
Well, I mean, they're supposed to be moving into the property, and it should be free and clear of any leases when you're getting in there. It also can hurt them in their loan, depending on the loan that they're getting. But I mean, it can be damaging every way. I mean, they're expecting to get into a property that doesn't have a lease, correct? Because the
Yeah.
seller didn't communicate that, or is that what you're saying?
Yeah, I think you're looking at the flip side, and that's
Oh,
okay because
sorry.
but it's whenever how I could have phrased it differently. If an owner changes the expiration date, then we're changing the termination of the lease and therefore changing the income of the property. So if we bought it
Oh,
as an income property and I don't get income in April, May, June, July, August, I don't get the income from that, then that can be very damaging. But to Nikki's point, that the flip side is also could be problematic. If I want to move in and I can't, having that lease extended could become a problem. So my like the friend says, "Oh my gosh, this new owner, what will they do with us?" So they come to the seller and say, "Please extend it to the end of the year so we're protected. I don't want to negotiate with the new owner of the property so the current owner extends the lease." This is all again could be a problem, especially if the new owner wants to occupy the property. And that was kind of what the way you looked at it, Nikki. So
yeah. I
yeah,
think I had an issue just recently with a property that the seller didn't disclose that they had a lease um on the property. However, the people that were in the property had never paid anything. So it ended up going to court with them too, but it was, making sure that there isn't any addendum or extension to that lease
yeah,
that's in there. Yeah.
yep.
Really quick in the chat, Ellen says reaffirming that any changes need to be addressed in writing.
Mhm.
Yeah, certainly prior to the change. So let's switch gears because we're going to go really quick, not just camp out on this one forever. But if we have changes during the contract or changes, just it says changes during transaction. So what other issues might we want to address in changes? So not just leases, but what else?
Remodeling.
Remodeling, right? So if the current owner takes on some kind of project while we're under contract without the consent of the buyer, this could be a problem. It may devalue it. Sometimes we get in arguments about that. Maybe they're saying, well, I'm repairing something. Well, a repair turns into a remodel. I've heard sellers say, well, I didn't really trust this buyer would see the transaction through anyway. So I just decided to do this project, as part of the repair. And it was, well, you did that without the consent of the buyer, and our REPC, addresses this. So you're right, Kev. Any kind of alterations to the property are a problem, or any kind of improvement to the property. We've had some issues with the leases being canceled or extended. That's the one that I've seen the most. Very rarely do I see a seller making an alteration to the property without the consent, but it does sometimes come up, and it is addressed in this section. And short-term leases are now part of this, and long-term leases. So, we had long-term leases, but now we have short-term leases are in there. So now you can put that back up on the screen, Mike.
Okay.
So 12.5. Matter of fact, Mike, go ahead and read that one. I'm not going to put everyone on the spot on this one, but this is a good reminder about short-term leases.
Yeah, 12.5, short-term rental bookings. If the property is made available for short-term rental bookings as defined in section 6.1b, seller may not, after the seller's disclosure deadline, continue to accept short-term rental bookings for guest use of the property without the prior written consent of the buyer.
You know, being a test writer for a while in my Stringham days, you know what a really good wrong answer to that question would be? Like, so the question is, when does a seller need to halt offering or taking short-term bookings? A, once they are under contract. B, seller disclosure deadline. C, due diligence deadline. D, upon the closing and settlement of the property. So the best wrong answer is once they're under contract. Isn't that interesting? That we go under contract, but we still have until the seller disclosure deadline to take short-term rental bookings. Isn't that interesting?
That's
Go back to that
interesting.
again.
Oh, you want to reshare?
Yep, put it back up. Yep, reshare that again. See, the good wrong answer, the one that everyone would hit, is once you're under contract with a buyer, you can't offer it as short-term rental. Not true. Seller may not, after the seller disclosure deadline, continue to accept. They can accept short-term rental bookings up until the seller disclosure deadline. That's what the contract says. Now, if our buyer has a problem with that, that's an edit there, right? So I would grab an addendum. I'd say, in regards to section 12.5, seller agrees to accept no short-term rental bookings after acceptance. But that would be a modification, right? That in 12.5.
Wow, that's a good one.
Okay. All right. Let's go to authority of signers. In authority of signers section, this is where we're dealing with our partnerships, S corps, trusts, estates, limited liability companies. Someone who is going to now contract has indicated to you that the entity purchasing the property is one of these legal entities. And now we need a person to sign on that behalf. So what do you say to this person who's sitting in front of you who says, I'm going to contract now for this LLC or this S corp?
Need the legal documentation. Me too.
Okay, so this is a legally binding contract for purchase or for sale. And what is the person who is signing on behalf of this entity guaranteeing or warranting?
They have authority to sign.
Yes. So they are personally responsible because they are personally warranting their ability to sign. Now, do we have some reasonable care here to make sure that the person who's in front of us or the person we're sending documents to actually does have the ability to sign on behalf of an LLC or an S corp?
Yes.
Of course. Yeah, we have a reasonable care duty. Remember our fiduciary duties, reasonable care. We can't just always take someone's word for it. So that's the advice on section 13 is remember your reasonable care. We have to go a little further than just, well, you personally warranty this, right? Yes, I understand that. Okay, go ahead and sign. Yeah, we've got to go further. Do you have any documentation that shows that you are the executor of the estate? Or you're the signator of the LLC? So just keep that in mind. It spawns another thought, but let's put this on for next week, Mike. I want to share the document because I don't want to spend a lot of time finding it right now, honestly. But the how we sign on behalf of all these entities, and we'll maybe we can get that on for next week, okay?
Authority of signers. Yeah, I know that document.
You know the document I mean. Yep. Unless you can find it, really. If you can find it, fantastic. We can show it. Let's move on to complete contract. So what is the purpose of section 14, do you think? Why do we have to have section 14 in the REPC?
All parties will present a full and complete contract.
Okay.
Different documents at different times, so it constitutes a complete contract.
Okay, Jenny. Yeah, so we could have different documents at different times. So we need something to reaffirm, well, what is the actual contract? Do we have discussions? Like, will you buy it? Can I sell it for this? Will you purchase it for this? Will you move out on this time? Would you consider paying closing costs? What if these conversations are verbal? Are they binding at all? So conversations at open houses or in driveways, are they binding?
No.
Not binding. So in section 14, we reaffirmed that any kind of conversation we had does not apply. It's not a binding contract. So, Mike, do you mind reading that one?
Yeah, sorry, I'm in the chat here. We're on complete contract. Complete contract, paragraph 14. The REPC, together with its addenda, any attached exhibits, and seller's disclosure, collectively referred to as the REPC, constitutes the entire contract between the parties and supersedes and replaces any and all prior negotiations, representations, warranties, understandings, or contracts between the parties, whether verbal or otherwise. The REPC cannot be changed except by written agreement of the parties.
Pretty powerful section of the REPC. What the REPC is doing right here, if it were a cartoon character, is it's flexing. Lots of muscle. Like, I am most powerful. I don't care what we talked about. I'm stronger. I don't care what you wrote last week. You could have wrote it down on a legal pad. It doesn't matter if you signed it. I don't care. I'm still more powerful. So the legal concept here is called parole evidence rule. Have you ever heard that before?
Yeah.
Okay, some parole evidence rule. And the parole evidence rule means that oral discussions or conversations cannot replace or supersede a written contract. So in the eyes of the law of the court, a conversation has no bearing if there is a written agreement. Another way to say this is that evidence would not be allowed. So if you went to a court to argue a point of a contract, a written contract like the REPC, and one of your sources of evidence was a recorded conversation in which the seller said that they would include the hot tub and the refrigerators, not refrigerator, or even the horses in the corral, or all the implements that go with the farm equipment. If you had conversation with this and it was recorded and you went to inject this as evidence to show that the seller's intent was to include these things as included items, the law would say it cannot be allowed. It has zero value. It's almost as if they never happened.
By the way, Will, we
Yeah.
do have the signing authority ready to display. Would you like to display it?
Wow, you are amazing.
You know, I would love to take credit for it, so I'm going to go ahead and take it, even though Hillary and Linda has sent it to me
Oh, really?
split second.
Way to go, Linda. Way to go, Hillary. All right. Who can sign? Well, march us through that, Mike.
Yeah, who can sign? So this document, by the way, if you can download this right away. If not, send me a text or email and we will respond to it. Everybody has it. So a trust. So the signature line should look like that. Signature John Doe, and then signed with trustee for the Jane Doe Family Trust. The trust will dictate who has been appointed as the trustees. It will also define which trustee or trustees can sign. That person has signatory authority. Sometimes more than one trustee is required. If the original trustees are deceased, a successor trustee must sign according to the trust agreement. The Jane Doe Family Trust will be listed as the buyer. And by the way, this can get a little silly. I think we had one in our office with 7 signers, people who had to sign on the REPC. So it looked messy, but we got her done. LLC, Limited Liability Company. So the signature line will look like John Doe, managing member, Happy Homes LLC. LLC usually has appointed a managing member or simply a manager. The manager can also be a member, but they don't have to be. Also, a regular member can be given authority to sign if the managing member or manager are not available, found in the Articles of Organization. You need to have a client inform you how they have a signing authority. The state identified registered agent is not necessarily the same person who has authority to sign on behalf of the LLC. And the LLC will be listed as the buyer or seller. And the last one, no, that's not the last one. Power of attorney should look like this. John Doe, attorney in fact for Jane Doe. Jane Doe will be listed as the buyer and seller. We need to have a copy of the power of attorney document to close. An original, we need to be recorded by the title company. So we need to have that. And keep in mind, most lenders will require pre-approval of the power of attorney used for buyer borrowers. That's an important point. Make sure you check with your lender on that. Partnerships. So the signature line on the partnership should look as such: John Doe, John and Jay Doe partnership, and then right below that, Jane Doe, John and Jane Doe partnership. There are general partnerships and limited partnerships. For our purposes, both partners in a partnership would be required to sign an agreement. And everybody's favorite corporation, the S Corp, signature line should look like, I don't know why Spencer Cogswell shows up, but he does. Spencer Cogswell, President, Cogswell Cogs Incorporated. He has the authority to sign on behalf of the corporation, is usually given in the company bylaws. The president typically has authority per the bylaws and articles of incorporation. If they don't have bylaws, a resolution of the board of directors giving authority to an individual is common. The contract would be in the name of the corporation. And something to ask yourself when dealing with a corporation: should a REPC be used or commercial purchase or sale agreement? Wonderful question. A REPC should be used for residential contracts, and a purchase and sale agreement should be used for commercial contracts. And this is really the last one: the deceased seller estate without a trust. So the signature line will look as such: John Doe, personal representative of the estate for Jane Doe, deceased. The heirs go through a probate proceeding and determine who the representative of the estate is. That individual, once appointed, would sign the contract. Depending on how long ago the owner passed, they can either have a court determine who the personal representative is, or make a determination of heirs. Both work fine, but just depends on the length of time since the deaths of the property owners. And always, if you have questions, give your manager a call. There you go, Will.
Nice.
Hey, I'll just make one addition to that if you don't mind.
Sure, Kev, go ahead.
Rather than calling your manager, we're not the ones ensuring the transfer of title. It's the title company. They need to get copies of trust documents, all of those things that ensure that the right person is signed, because they're putting an insurance policy on there that says if they're wrong, they're going to have to actually correct that and even buy the house back if they sold it using the wrong signature. So word to the wise, always get those documents early on, right after it goes under contract, over to the title company. They do their search, they do their examination, and say, hey, you've got the wrong person on there. Don't find out the day of closing. Find out within a day of actually going under contract through your title company, who has to put an insurance policy behind their decision.
Yeah, and let me add one more. You know where I see the problem is I think we're pretty good on the listing side. I think we're pretty good on there. But when our buyer is in one of these entities, the same rules apply. I mean, we still have to do insurance for the buyer, especially when there's a loan, right? When there's a loan, we need to have that buyer insured, and there's still work done on the title side to confirm that the deed is signed appropriately, and we can still run into an error there.
I think it's just as important on the list side, Will, because we've had people who have said, I have the authority to sign for the family in an estate sale. They actually don't produce the documents. We take the listing. We trust that the person is right, and then they don't get a preliminary title report in advance to know what they actually need. And then you get to closing and find out that all 4 siblings have to sign. So now the REPC is invalid, and they can't insure it. So it's good to find that out early on before you spend lots of time marketing a property and money, and time to find out that you've got the right person on that signature, not the brother who thinks he has the authority to sign for the estate.
Yep.
Hey, and I'm sorry, on that note, Kev, you teed me up perfectly. If there is a buyer in there as well, guys, just make sure you drop that information in the loop, or partner with your title company, right? Call Jeff, Jesse, whomever, or your lender, and get it into the loop. It's so much easier that way, and we can track all the updates as well. So it's a terrific circle of information.
Yep.
Love it. Okay, good input. You ready to move on to the next one?
One other quick thing on the complete contract when you were there.
Yeah.
It says this contract, together with all its addenda and any exhibits, constitute the entire contract.
Yep.
and whatever. People forget that there's one last addendum in every transaction. What is it?
Oh man, this is a great.
One last
The set,
addendum.
You are
the
right.
settlements,
People do
the
forget.
settlement statement.
Oh,
Where
yeah.
you get to the closing table and there has to be something adjusted. You don't have to go get an addendum and amend the contract. Both parties can sign and agree to a change on the settlement statement. That becomes part of the final contract.
Really good one, Kev. Nice job.
Man,
Now,
primo stuff.
somewhere.
Wait, Kevin, say that again. Sorry.
So the complete contract is the contract, all the addenda and exhibits. But if you're at this closing table and you find out that there's a $200 fee for something that wasn't agreed to by one party and one party agrees to actually pay it, you don't have to go get an addendum to the contract, send it to both parties and have a new addendum signed to hand to the title officer. The title officer can change that on the settlement statement with the agreement of both the buyer and seller. And that last settlement statement which they both sign becomes a part of the contract. It's the last addendum to every contract.
Okay, thanks. But how about if you're gonna supposed to close tomorrow and it might take another day and you're closing on Monday?
Yeah, if you have time to do an addendum, it's great. But a lot of times you don't. You're doing it on the fly in the title office. And the closing document, the settlement statement is supposed to represent everything that was agreed to in the contract. But due to some unforeseen circumstances, something changed. And now you're sitting at the title company and you don't have to go cancel your settlement and go get another addendum signed. You make the adjustment, both people agree to it, and the title officer makes a change to the settlement statement. That's the last addendum to the REPC.
Okay, thanks. That's great to know. Thank you.
And
Yeah.
since Kevin brought that up, one of the most fantastic points, because that will catch your lender. So just make sure your lender is either present at closing with you or can deal with the adjustment, because the settlement statement is the addenda. Then we'll need to go back and reconcile with your lender and your final closing disclosure and offset the loan price or the discount by the difference. So just keep in mind, there's one extra step if your buyer has financing.
Yeah.
Go to section 4.1 real quick. There's a tie-in with what Kevin was saying here. I was searching frantically with where does it say this? Where does it say this? So prorations, assessments, and other payment obligations. So this says prorations. All prorations included but not limited to homeowners association property taxes for the current year, rents, interest on assumed obligations, if any, shall be made as of the settlement deadline referenced in section 24D, unless otherwise agreed in writing by the parties. Such writing could include the settlement statement. Do you see that?
Correct.
Yeah, referencing prorations or any kind of payments, such writing could include the settlement statement. There's one other place. If we have time, I'll find it. But there is one of your tie-ins to Kevin Larson's concept here, is that the settlement statement is modifying, in some cases, even minor modifications, the REPC itself. But the REPC gives the settlement statement the power to do so. And where does it do that? Remember, the REPC is the one saying, I'm the most powerful, but it gives power to the settlement statement.
Yep. It's usually a homeowner's dues or some adjustment there, or, hey, we're not going to be able to record because of something that happened until Monday. So we're going to change the prorations from settlement to actual closing. So those things can happen right at the settlement table, and the REPC speaks to it.
Yep. Okay, let's go back to 14, Mike. Pick up where we left off. So what was that term I said? What was 14? What was the
complete contract, wasn't it?
Yeah, and what was the real estate term?
Full at-
Go ahead, Rachel. Raquel? Anybody? Who had it? Someone had the answer.
Yeah, but the parole of evidence.
Parole evidence rule. Pam, nice job.
Oh man, that's 1,000 bonus points for
That.
sure. 1,000, easy.
You go,
Yeah.
girl.
Yeah. Okay, so parole meaning oral. Oral evidence not allowed when it contradicts a written contract. Okay, let's go to mediation. This one is often misunderstood. What's better? We sometimes get the, which box should I mark, shall or may? I've heard the argument made that, well, wouldn't everybody like to have the option to mediate? Why don't we just always keep that on the table? So just mark option to mediate. And then we have this shall, like you first have to mediate before you take other legal measures. We did a class on this, Mark and I, a couple of years ago, and it was this, shall or may, the great debate. Should it be shall or may in all these Where do you think, like if we took 1,000 transactions, what percentage of those, or 100 transactions, what percentage of those do you think are better off having shall marked? Anyone want to take a guess?
It's 100%.
Well, that's a good answer, but it's not the best answer. So not 100% of the time. But okay, I'll just help you guys out. Shall should probably look. Shall is our best answer 90% of the time. Well, when is it not the best answer then? Well, when the parties have legal representation or that they have other ways for legal remedies, and they have the legal support and it's funded. If the legal support is funded and they have access to it, then that may not be the best remedy for them. But most of the time, the remedy is to first mediate the problem, to lower the legal costs so that real estate transactions do not become so costly in litigation when there's a disagreement between the parties that the whole entire transaction is a massive turnoff to everyone. And we talk about the fact that real estate is has litigious nature tied to it. Well, why is that? Well, it's a contract. It's high dollar amounts. Okay, that those two things are going to drive the higher probability for litigation. So Section 15 is a friendly paragraph to the consumer. When you enter a real estate transaction, you're better off having mediation as your option first in almost every case. So that's basically the summation of the 1 hour CE class that Mark and I did. Okay, and then we provided all. I just saved you 1 hour of your life. Although that was a great class, shall or may, the great debate. So it's still on our internet site if you want to take it. So, anything else on mediation, Mike, from your point of view?
No, I think we covered it pretty well.
Okay, let's go to 16 then.
Okay.
When do you guys use 16? Do you ever go to 16 when someone says something like, how much earnest money should I put down? Or do you ever talk about, with your buyer when they fill out the REPC, well, what happens if they default? Do you have a dialogue that you go through here? Or do most of you just have these conversations without looking at the paragraph?
Kristen says, yes, part of my buyer consultation.
Okay, so look, I kind of, maybe I gave you the answer in my question. When a buyer asks you how much earnest money to put down, this seems like one of those paragraphs we should go to, because what happens is deposit. Why do we want to put earnest money down in anyway, in the first place? Well, when we read section 16.2, if the seller defaults, the buyer may elect one of the following remedies, either to cancel and have their earnest money returned. Okay, and buyer may elect to accept from the seller as liquidated damages a sum equal to the earnest money. So stop right there. The seller has to match your deposit if they default. So the lower the deposit, the lower the match. If I put 1,000 down, I get only 1,000 back of my own money, and the seller only has to pay me $1,000 regardless of the damage they caused me. If I put $100,000 down, the seller would need to match the $100,000. And earnest money becomes so that, and you should know this on what is the term of debt? What's the legal definition of liquidated damages? What is liquidated damages? So seller agrees to pay liquidated damages upon demand. What does that mean? Buyer may elect to accept from seller as liquidated damages. What does that mean?
Ellen says earnest money.
So the legal definition is typically when you're signing the contract, you don't know what the actual damages may be if the buyer defaults, because a lot of factors play into it. So it's a fluid situation, and therefore it is liquid. We decide up front what the damages will be, regardless of what the circumstances are.
What Kevin just said, if I saw that in text, what I'd highlight is that we anticipated, we were upfront about, now we're contracting to enter a real estate purchase contract. We're anticipating what the damages might be upfront because we don't know what they're going to be. And that's exactly what liquidated damages are. It's an anticipation of a default. So we're taking a guess and we're agreeing ahead of time. If you harm me, and I don't know what that harm will be right now, but if you do harm me, then I'm expecting this back. And now I will contract with you. Okay, so liquidate, I think what we miss in liquidated, we think liquid is cash. And in part, yes, but we miss the contract perspective of this. The contract perspective of this is that it's an anticipation of a default. So we're looking ahead. And that's really important for the buyer to understand because they're the ones who are going to set initially what the earnest money deposit is. What happens if a buyer wants to go another legal route because the seller defaulted? May they do that? And if they do, what happens to their earnest money? If the buyer decides they want to sue the seller for damages, maybe they've determined that those damages are way more than their earnest money, then what happens to their earnest money?
Don't get it back.
Where does that earnest money stay? I'm giving answers in my questions. You picked that up, huh, Kev?
I'm laughing because it's not this remedy and this remedy and this remedy. It's and or. You get one of the three.
That's right. You don't get to have your money back and then go take that money and pay for an attorney.
Yep.
So that earnest money is stuck in that trust account. It's going to stay there until there's a legal outcome. So if you choose a lawsuit route, the earnest money deposit stays tied up. And I've heard buyers want that money to pay for an attorney. They can't do that. They're not going to get their earnest money, pay for the attorney, and then make a lawsuit. It's not, you can have, like Kevin said, it's an or scenario. Again, a really important thing to understand when we go enter a real estate contract is this earnest money, why, what is it? How does it work? What are my remedies? If I get sideways with a seller.
One actually defensive tactic is if the seller's in the wrong, or if the buyer's in the wrong, by volunteering to give up the earnest money, if it's a lower amount, it then locks them into the fact that's your only remedy. You can't sue me now.
Yeah, that's right. Look, I'm going to read this to you. I have on my phone an app that has the Barron's Legal Law Dictionary. So here is the definition of liquidated damages. You ready? Liquidated damages are a predetermined amount of money specified in a contract that a breaching party must pay to the non-breaching party if they fail to fulfill their obligations within a set time frame. Again, it's an anticipation. And I think we miss that when we're explaining it to our buyers. It's a predetermined amount up front. See, we look at earnest money like I want to show how serious I am. And I think that's, well, if you're really serious as a buyer, you put more down. But we don't explain why that is. Because it's protecting the other party with setting aside monies in case there's a breach of the contract. And the options are limited, to Kevin's point. Okay. Any other questions or perspective on that one, Mike?
No.
Okay, let's move on. Really, I got an interesting case on number 17 I want to tell you about. So 17, attorney's fees. Remember this one? So in the, Mike, go ahead and read it. Save my voice for just a second.
Yeah, 17, attorney's fees and costs governing law. In the event of litigation or binding arbitration arising out of the transaction contemplated by the REPC, the prevailing party shall be entitled to cost and reasonable attorney's fees. However, attorney fees shall not be awarded for participation in mediation under Section 15. This contract shall be governed by and construed in accordance with the laws of the state of Utah. The provision of Section 17 shall survive closing.
Look, I'm seeing through this, and Mark and I had a discussion before to make sure I was on the right page here, and I'm proud to say that I was. It's 34 years of real estate, and owning a real estate school is helpful. Being a principal broker of a company this size is helpful too. But I'm reminded of a situation where we did a mediation. We had a judge as a mediator. The amounts were started off about $80,000. I think I've told this story before. It was Christmas Eve. And we were on the seller side, and our seller was accused of withholding information that was factual related to a rotting deck. But the big item was the sewer line, and how the trees in the front of the yard had gotten in the sewer line, backed up, caused damage. There was a couple other things like not having enough ventilation in one of the bedrooms, slow draining toilet tub, it all kind of tied together, 80 grand. Okay. There was so this judge is very sharp, 80-year-old, a retired judge, very, very sharp. And I remember learning this principle as he said, because there was a discussion about attorney's fees and what the seller was faced with. He was either going to pay the damages at a settlement that day, and we'd been there all day, 6 hours, at $300 an hour per side for the mediator, by the way, per side. So $600 per hour, where we're like, it's continuing to tick, and everyone has to pay their share. And then we have attorneys that are representing each side. You're paying them by the hour. So, and we'd been there 6 hours already, locked in conference rooms, 2 different conference rooms. And it goes from 80,000 to 56,000 to 47,000 to 44,000. And it comes to this point where it's talking about reimbursing attorney's fees, because now attorney's fees are it's not just that day, but it was all the attorney's fees even up to this point. It's thousands and thousands of dollars for each side already. And this is real. And the judge mediator, the attorney representing our seller in this conference room said, we need to talk about awarding attorney's fees on a few of these issues. And I learned something here. Now, so 17 just said, the prevailing party shall be entitled to costs and reasonable attorney's fees. The problem with that statement that I learned is that is this big, massive blanket statement that there's a winner and a loser in a litigation. And that's not the case at all. You're going to win some terms and you're going to lose some others. So how do you determine who wins or loses? By someone who pays, who does not pay. You see how that can be a problem? Because the 17 is one of these statements that we warn people that there is a concept of having attorney's fees paid if you just get reckless with your lawsuit and you lose. That's why it's there. But to make a blanket statement like there's a winner and a loser in litigation in real estate, and then whoever wins, congratulations, you also have all your attorney's fees paid? No, not at all. So what the judge said was there is no there. So why did the attorney bring this up? Well, because our seller was at risk of having to not only pay the $45,000, but to also pay for the attorney's fees to defend the buyer and to bring the litigation against the seller. And you could say, well, the buyer won, right? So the seller walks out of there that day having to pay $40,000. Who won? Who's the prevailing party? Would you say the buyer was? Well, the buyer looked at it like, yeah, but the damages were in excess of $80,000. So how did I win? All right, you see what I mean? It's hard to sometimes draw the line as someone won or lost, and then now attach that to attorney's fees. So be very careful about any of that. Legal advice, right? We go, hey, I can't give legal advice. If you feel like you need an attorney, please have this reviewed by an attorney. This is a legal binding document, all those things. Anyway, that I always remember that when I read section 17.
So Kevin, what happened?
Oh, this is Will's story.
No, Steve, what happened that day is the seller, well, there was another, let me give you a little more juicy content here. There was the attorney got on the phone and called the home inspector who was there to fix some of the line of the sewer line, but the seller told him, don't send a camera down that line. And the evidence that just hit him right between the eyes was this testimony from the inspector that says the seller instructed me specifically to not send a camera down that line. He didn't want to know that line was clogged. And that we sat there and read the typed out deposition of the interview with the inspector in which he said this. And this was a very good witness for the buyer, and the seller just caved, and he said, "Yeah." He even told me, the attorney walks out of the room. I'm just in there with our seller, and the seller says to me, "Gosh, Will, I just didn't think that was a big deal. I thought it was better to not know." He goes off. He starts off. He goes off the record, and he's looking. I go off the record. You're telling me off the record? We've been here 6 hours. Like, I don't even know what that means. And he says, yeah, I thought it was better to not know what was down that line. And then, in comes this deposition where the inspector says, yeah, I was told not to send a camera. So what did it end up being, Steve? What happened that day is that seller wrote a check for $42,000 for the damages.
Ooh.
And I remember him telling me privately, he goes, Will, I only have $30,000 in the bank. And back comes in the judge with this final offer. Like, this is it. And if not, we're going to trial. And then the attorney representing the seller privately with me in the room says to our seller client, look, it's going to cost me at least $30,000 to get you ready to defend you in trial. Okay. So we're already at 30 grand, and they have a case. And the judge says, by the way, their case would pass summary judgment. I think I've explained this before. So summary judgment is this phase in which the court looks at is there enough evidence that there's a legitimate argument that should be heard. They don't have to make a decision. They're not making a judgment or a decision, but they're making an observation of the evidence that it passes summary judgment. And the judge said this would pass summary judgment. And the attorney looks at my seller client and says, you should listen to that. That's important for you to know. This judge is telling you it will get past summary judgment, meaning if we don't settle this today, we're going to go to court and we're going to lose. We're probably going to lose, and I have to defend you, and it's going to cost 30 grand. So in comes the final offer of $44,000, in which he agreed to.
Yeah, so in reality, you're saying the seller effectively paid the legal fees for the buyer because his position was weak and that he did not win in this case.
Related to attorney's fees, no. He only paid the damages. That's the point I was trying to make, is that you could argue that the buyer prevailed. Remember, the REPC says prevailing party entitled to fees. You could argue they got a settlement for $44,000, therefore they prevailed. But that's not how it all worked out. There was not enough. It wasn't that clear cut, Steve.
Okay.
And I think that's an important thing for us to remember is that's really the nature of the law. It's not that clear cut, which back to that section, pull it up again. Notice what it says right after that prevailing party. It references. Go ahead. 1, 2, 3. There it is. 17. However, attorney's fees shall not be awarded participation mediation. That's obvious. This contract shall be governed by and construed in accordance with laws of the state of Utah. I mean, why say that? I mean, hello, of course it is. This is the state of Utah. This is a Utah document. Well, the reason for that is because of what I just pointed out. Is in the state of Utah, it's hard sometimes to draw the line of prevailing and not prevailing, and therefore award attorney's fees.
Okay, great.
Okay, the reason we have it, though, why do we have the language then? It's to stop the frivolous lawsuit. If it's very obvious this is a frivolous lawsuit, you're going to pay to defend the other side. Frivolous lawsuits, you'll end up paying your attorney to make the argument and then defend the argument. Okay? All right. Since we only have time maybe for one more. Okay, let's do 18. 18 notices. Mike, go ahead and read that one. We'll make this our final one.
Yeah. Paragraph 18, notices. Except as provided in section 23, all notices under the REPC must be A, in writing, B, signed by the buyer or seller giving notice, and C, received by the buyer or the seller or their respective agents or the brokerage firm representing the buyer or seller no later than the applicable date referenced in the REPC.
Awesome. Okay, here's your situation. Feel free to weigh in on this one, Kev, but let's not use agent names, but here's we get a text message. Agent gets a text message that says, let me just give me a fictitious agent's name. Anybody?
Will Cooper.
Who? Will Cooper. I know.
William Cooper.
There we go.
Yeah, I always use Ken Adams. Does anyone know why I might use Ken Adams?
No.
For bonus points, put in the chat why you use Ken Adams. If anybody knows why that is. I'll give you a hint. It's from a sitcom, but you know.
Joey Tribbiani.
Yeah, there you go. That's right, Sandy.
Man.
Joey Tribbiani's nickname when he's trying to go undercover is Ken Adams. Okay. So Ken Adams is under contract now as a backup offer on a listing. He represents the buyer and he gets a text message that says, "Hey, guess what, Ken? Our first offer is failed, and it looks like you're going to be the primary offer." Is that notice that I'm now the primary offer and therefore starts all the dates ticking? I mean, it was in writing. It was a text message that says, "Hey, guess what? Good news for you, Ken. You're now
from the agent." From the agent, though, not from the seller giving notice to the buyer.
Yeah, it was not even buyer. It wasn't. That's right, Kev. It wasn't seller to buyer giving notice. It wasn't principal to principal. It was an agent saying, "Congratulations, Ken," who's also an agent. "Your offer is now the primary offer." I'm not making this up.
Right. And felt like she didn't need to actually send that because the seller was her sister.
That's right.
So her text message should be good because she talked to her sister.
Yeah.
But now they're suing for us not collecting the earnest money because the buyer decided we never got written notice, so they went out and bought a different home and no longer interested in moving into backup position because they never got a formal notice putting them in backup position. And the seller is now suing our agent for $80,000 or $100,000 in earnest money.
Gross.
Yep. Well,
But is the question the fact it is a text and not a written response? I mean, is that
Yeah.
the key?
Well,
Okay, great.
All notices have to be in writing and signed by the party giving notice for it to be effective. There was no formal notice given.
yeah, remember, let's go back to section 14 where the REPC is doing its flex and it's saying, "I am all powerful." Okay, so the REPC says, "I set the rules." And nothing in the REPC says a text message from my agent shall constitute a notice. Nothing in the REPC says that. Matter of fact, it does define notices of must be in writing from the principal and then signed. So where does a text message from an agent have a signature from a seller? Nowhere. And remember, the REPC is all powerful. So these points are clearly our counter argument to this claim that there was no written notice. So remember, our jobs as agents is to make sure our principals have enforceable contracts. And in order to do that, we've got to follow the rules of the REPC, and the rules of the REPC say notices are in writing and signed by the party giving notice. Okay, well, I think that any questions or comments on that, or anything in the chat undone, Mike?
I think we're good. I think we covered everything in the chat, and we got from 12 to 18, so not bad. Not bad.